apologies. Welcome today to Top 10 Legal Tips for Content Creators and the Agents who represent them. It's my pleasure to present to you. My name is Jean Hamburg. I am a partner with Norris McLaughlin, which is a 120 person law firm. And I specialize in intellectual property as well as founded the creative economy and media law practice. Before we begin, I just wanted to let you know that this presentation is generally geared to both agents and influencers. So anything I'm talking about today will be applicable to both groups of people. And in addition, if there are any questions, I would love it if you would just put them in the chat or Q&A boxes, and we'll look at those at the end of the presentation so that I can address them at that time. So the creative economy is a huge business. The New York Times last estimated that it would be worth $500 million. But at the same time, I've noticed as a practicing attorney that legal formalities haven't been observed as much in this business as in others. Perhaps because we're all mini entrepreneurs and everyone is starting out as an influencer pretty much on their own. And so it's akin to having just millions of small businesses. And my goal today is to give you some legal tips that will help you to operate more like traditional businesses in some respects, but also to think about, the big picture, the long-term planning legally for your business, and make sure that you take care of those legal formalities, because at the end of the day, if you don't, you're essentially leaving money on the table. So the first tip, and I've styled this as top 10 tips, the first tip is to consider your brand, whether you're a talent manager or an influencer. This is a source of untapped money. If you brand, then you can repeat, license your brand goodwill. You can merchandise. You could have independent value when you're making brand partnerships. And so it's really critical that you pay attention to a brand. What is a brand? A brand is really anything indicating source. So that would be a personal name, or it could be a saying that you're known for. It could be the title of a serial production or a series of posts or webisodes. The important thing is that when a consumer or a user hears or sees the brand, they think only of a single source. And brands are established through use in commerce. What does that mean? That means exposure to the public. It can be through sales if you're aligning the brand with merchandise. It can also just be through subscriptions to your content. But anytime you are exposing the public to your name, the public is coming to identify that name with you. And that is what a brand is. So next slide. So brands help set you and your content creation apart in the marketplace. If you produce good content, or if you're offering excellent services, consumers will come to identify the brand with the excellence of the product, and will come to know that you produce high quality content or excellent management services. So there's a significant competitive advantage in having the brand serve as a sort of shorthand for the quality of what you're doing. And also, properly protecting your brand means that others can't copy it, which is critical in today's day and age where all of this content is available publicly online. Next slide. So when you're choosing a brand, some brands are better, some names are better than others. You shouldn't pick anything that's too descriptive, because it would be considered generic. That is like a product category or description that could apply to any one of a number of producers' goods. So the best makeup, powerful hair tools, these are examples of generic phrases that will never be associated exclusively with a single source. be imaginative and creative. Some great examples of cosmetic brands that are very inventive are Sephora, or the acronym ELF, or even Eyes, Lips, Face by itself is inventive enough, not descriptive, not generic. MAC Cosmetics. These are all examples, and you can actually use a word in the English language. You don't have to make up a word like Sephora did. You can use a word that has never been applied to the kinds of goods or content that you're producing. So Apple for computers, for example, very inventive use of a common name for computers, completely unrelated, right, to fruit. The bite out of the apple, that's a great, reference to a biblical story. It's a very evocative, it suggests, the beginning of something new. So these are creative brands. But sometimes descriptive brands do become associated with a single source. So New York University is geographically descriptive. Scholastic is very descriptive of scholarship and books. Yet nonetheless, these have become brands over time. And it's generally best, though, unless you've been using the descriptive name for a very long time, to try to pick something inventive to begin with, because you'll have a much easier time protecting it and getting a trademark registration. Now, what else is important when you're picking a brand? Clearing it is really critical. What does that mean? It means that you make sure that nobody else out there is using the same or a similar name for the same or similar content or services. So if somebody else is influencing under a brand that you want to use, you do not want to use that name, right? And how do you figure that out? Well, you could do some searching online, but that's really not going to be enough, because in the United States in particular, parties can have trademark rights even without registering. And I'll talk in a little while about the advantage of registering a trademark with the US Trademark Office. But right now in this country, there are lots of people who don't have trademark registrations who nonetheless have valid trademark rights. So in order to pick up all of those rights and to make sure that you are steering clear of any third-party rights, it's really best practice to have an attorney do a clearance search and review that search and make sure that the report does not identify any problematic references. And typically, like our firm and many others, work with vendors who specialize in these kinds of search reports. They can be, a couple hundred pages long, 500 pages long. I've even had ones that were over 1,000 pages when the brand was very common. And the attorney reviews the search report, looks at what the other names are being used for, and determines if the name that you want to use, the brand that you want to use, conflicts. So it's not just a quick search online, it's more involved. A good attorney will give you a clearance opinion, and that clearance opinion can serve as good faith, as your good faith if you do in fact get into a legal dispute. And generally speaking, when I clear, I am not seeing problems later that we didn't know about down the road from that search report. So always clear your brand. Okay, next slide. We're on to tip number 2. I mentioned I was going to be talking a little bit about applying for your brand in the United States Trademark Office. So as I said, brands can exist without a trademark registration based only on use in commerce. Nonetheless, you will get nationwide exclusive rights if you file for a trademark with the US Trademark Office. And moreover, once you get your registration, that's worth a lot more money than a common law mark, what we call a mark that has not been registered. So in addition, your rights are limited without that trademark registration, because you only have rights where your content or where you're selling subscriptions or where you're providing content. This may be less relevant with content that is available through the internet, but nonetheless, it is important if you are going to be merchandising. And so if you have a situation, as I did with some client in the past, where someone is only selling in a limited area or only providing services in a limited area, they may not have trademark rights beyond that area, which was the case with a party planning service I helped, who only had rights in certain territories. And then somebody else came along and took the same name, came up with it independently, and started selling in a different territory of the country. And we couldn't do anything until we got a trademark registration. And then, even then, we couldn't do anything about the preceding use by the other brand. So we ended up having to enter into a settlement agreement. So this is just a cautionary tale of how that my client has allowed me to share with you, of how not applying for a registration promptly can get you in hot water later. Okay, so go to the next slide, which is about copyright. So what is the difference between copyright and trademark? Frequently confused concepts. So a trademark protects a name or a slogan or a symbol, or even sometimes a color like Tiffany blue, or pink Corningware installation. But a copyright protects creative expression. And in particular, it protects the content that you're producing and streaming or making available online. And copyright includes not any one right, but a bundle of rights, meaning that all of these different rights attach to creative expression. That includes the right to display or distribute or reproduce or perform or adapt the creative content. So when you are posting to social media, you're actually giving the platform a license to do some of these things, to display your content, to distribute it, to the degree it must for the social media platform to function, to reproduce the content. But what you're not giving the platform is the right to adapt it in any way. That is still your right. So why should you copyright your content? Because it will prevent plagiarism. And on the next slide, I talk about the kinds of things that might be of interest to you to register copyright in. So obviously your posts, a particularly important photograph or series of photographs. If you have a website or podcast or webisode, these are all copyrightable works. And in addition, you want to make sure that when you are involving third parties in what you're creating, that you're getting the rights to, their rights are being transferred to you, whether through a license or ideally through an outright conveyance. And I'll be talking about copyright conveyances in a little while, but typical examples where you might involve third parties would be when you have crew, a filmmaker, somebody editing an audiovisual production, or someone writing a script for you. And then in other situations, you might be using material that others created and you're only using under license that you can never own. For example, if you are licensing third-party music, in that situation, that is not part of what you own in your copyright. Okay, next slide. So I mentioned before that I would be talking about copyright conveyances, and my tip number 4 is it involves exactly these types of conveyances of copyright. What do I mean by conveyance? It's when the copyright is transferred to you or from you, and it's kind of like when you sell a house. Copyright is intangible property, and you can transfer it. Just the way you can transfer ownership in a home, title in a home. So the two kinds of conveyances where the entire copyright is conveyed are called an assignment or a work made for hire. So a work made for hire is commissioned in advance, and it includes it commonly includes, in the context of influencing, certain kinds of works, including audiovisual works, most notably. And it arises as well, in addition to when you're commissioning works, it also arises if you have a full-time employee creating content for you. Now, the difference between those situations is that when it's a special commission and you're involving an independent contractor and helping you create your post, in that situation, you have to have a writing that says that it's a work made for hire. What does that mean in the end of the day? That means that the commissioning party, you, will get ownership of the copyright. Okay? If you don't have that writing when you're dealing with an independent contractor, you will not own the copyright. The other situation in which work made for hire can happen is when you have a full-time employee. And in that situation, assuming they are really full-time and they're doing work for you in the context of and as part of their duties, employment responsibilities, then in that situation, you do not need a writing. And once again, you are the owner as the employer of copyright. So those are the two different examples. One, you need a writing with the independent contractor. One, you don't when it's an employee. And the other kind of conveyance is an assignment that conveys the entire copyright. And in that situation, you're not, the rights are somewhat different in that you're not considered the author of the work. In a work made for hire situation, you are considered the author. There are some other long-term consequences of an assignment versus a work made for hire. A work made for hire can never be terminated by the conveying party, but an assignment can be. But it's not for 30 years after the original grant or the work is published. So it's a very long-term issue. But in some situations, you may actually be taking a license rather than an assignment or commissioning a work made for hire. And that's because the person that owns the copyright or entity that owns the copyright will not convey copyright to you because they license it over and over again. A great example of this is music, right? You'll probably be getting non-exclusive rights in music, and the composition, a recording, or a right to make your own recording. But these are all situations where a license is more appropriate. When you're dealing with a brand, oftentimes they will want an assignment or to commission you as a work made for hire author, to commission you as work made for hire contributor to whatever it is they've asked you to produce. So you can be on the flip side of this as well. But maybe in certain circumstances you won't want to assign or agree to a work made for hire. And in those situations, maybe you would prefer that at least some of the content you're producing be licensed rather than copyright being assigned in it so that you can use it again. Okay, but importantly, all of these issues about conveyances, they always involve the exchange of money. So it's understanding what you're doing and whether you can use content again or whether you've given away rights to it under the copyright law is really important to your bottom line. Next slide, tip number 5. So I've listed here a large number of common terms in endorsement agreements. When you enter into brand partnerships, what are things that you should be sure your contract contains? It's a really good idea to have an attorney look at the agreements. You can develop forms, but every agreement can be different, and sometimes something new will come up, and you'll be best served by having an attorney look at it. Even agents who deal with things time and time again sometimes find counsel is important. So these are just general terms but as I write here, the devil's in the details. You're going to have to look specifically at what the provisions say, but obviously you're going to want to address the scope of the services that are being performed for the brand, what platforms are going to be implicated, what kind of content is going to be produced, the minutiae such as the number of images, the quantity of the content, whether there are messaging or marketing requirements that the brand wants you to meet, and are you going to have an obligation to continually market the content that you're producing? Is that something the brand is going to be taking over, or are you going to be doing that? Who's going to be managing social media? Is it going to be you? Is it going to be a brand? And are you going to be required to appear in real life for events and other promotional opportunities that are not taking place virtually. What are your deliverables at the end of the day, and who is going to own what? That is the copyright question. What kind of grant is being negotiated? Is it going to be an assignment, a work made for hire, a license, all the things we talked about before? Is there going to be any attribution to you, and of course, attribution to the brand? Who, how much is being paid and when? Who is bearing the initial burden for expenses? Do expenses have to be approved before they're paid? How long is the term of the contract, and can it be renewed, and how will it be renewed? And is it an exclusive or non-exclusive endorsement? Are you allowed to negotiate with others in the same field for similar endorsements? What are the limitations on your ability to negotiate with others and reach brand endorsement contracts with others? That should be fairly narrow. It should not be. You should be careful not to be exclusive, except as with respect to a particular product or service category. Of course, the FTC regulations loom large, and I'll be talking about those as a separate item, but it is important to understand who's going to be responsible for FTC compliance. Are you going to be getting guidance from the brand? And are there liability shifting provisions? In other words, is the influencer agent on the one hand, or the brand responsible for clearing third-party content that's used, content to which the creator does not own rights? And is there media liability insurance? That's really important because these third-party disputes can get very expensive, and you want to make sure that there's some coverage, whether you yourself take out media liability insurance, or whether the brand adds you to their policy. And when is there a breach? And under what circumstances can an agreement be terminated? Does an agreement always have to be terminated for cause, or can it just be terminated for no reason? Are there provisions for attorney's fees in the event you don't get paid and you're forced to collect? Is there a right of pre-approval over the content that's created, and what kinds of confidentiality provisions are in the agreement, what you can share and what you can't share? And then there are standard terms like where disputes are going to be resolved, and what law applies if there's a dispute, and clauses about whether the contract can be modified and how it can be executed, all standard provisions that should be included. Next slide. So AI is getting a lot of attention these days, and for good reason, and it perhaps impacts the business of influencing in a way that is unique, because it is so easy to replicate persona, whether it's name, image, voice, likeness. All of these attributes of one's personality are embraced by something called the right of publicity. That's the legal right underlying your control of your own voice, image, or other attribute for commercial purposes, for profit. And nobody can use your persona without your permission because of the right of publicity. So an influencer agreement, an endorsement agreement, is actually, in some ways, can be thought of as a grant, a license of the right of publicity to the brand, who is then able to use with your permission, your voice, image, likeness to promote its goods or services. But the wrinkle with AI is that it allows so easily for the replication of voice and image. And just a case that people may have seen in the news is when Tom Hanks voice and image were being used without his permission to promote a dental plan. And as you can see here, Tom Hanks had to educate the public as to the fact that he was not, part of this endorsement. He had nothing to do with it. And in addition, however, AI offers many benefits. becomes ever easier to create inventive content by using AI. But more importantly, it can reduce the time and resources you spend on creating content because it eliminates the need for doing a shoot, which is much less expensive. And you can control what images and AI created material is being used by the brand by making sure that you have pre-approval rights. But it's wise as well to limit how much AI can be used and be very clear on pre-approval rights, and also insist upon the destruction of any AI content that's not used as part of a promotion. It is also possible that you want to prohibit use altogether of the AI because you don't think it would serve you well. Okay, next slide. So this next slide is devoted to something called the Digital Millennium Copyright Act. And the DMCA addresses infringement of copyright online when it's not always possible to identify who copied the content, who was the bad actor. And so what do you do if your own content is removed, probably inadvertently due to a claim of copyright violation? Well, if the content was cleared in advance, as hopefully it was, then you're not going to have any issues, with getting it restored. You're going to want to counter notify the social media platform, explain that you had the permission and that whoever complained about it was mistaken. And the counter notification requires, that step requires reposting of the content within 10 days if the copyright owner doesn't bring a lawsuit, which most often doesn't happen. Now, if the content wasn't cleared, you're in a totally different situation and you're going to need to clean up the content or reproduce the content in a way that does not infringe third-party rights. A lot of the social media platforms are a lag on DMCA claims, and sometimes you will not get your content restored in a timely way. And a lot of times your agent can help you with that. And if not, an attorney can always contact the general counsel's office of the social media platform's owner and get wrongfully taken down content restored. And importantly, in your brand endorsement agreements, you're going to want to make sure that if content is taken down, you have no control over that takedown, of course, that's not considered a breach of your your obligations as an influencer. Okay, next slide. So tip number 8 is somewhat related to our prior tip about takedowns because it encourages you to do pre-publication clearance. So pre-publication publication can occur in any media, including social media. And it's when the content gets posted that's published, because that's when people can see it. And ideally, you're going to want to make sure everything is cleared. You have rights in everything that's a component of that content, a component of that post before it goes up. And an attorney can help in more complicated questions when there are third-party rights issues that a creator or agent may not think of. For example, a commonly overlooked issue is a sync license. So even if you're if you have rights or have gotten permission to use music, that does not cover syncing of the music to the images. So there are websites that purport to give you rights in music. You should always carefully check those out. There's also BMI and ASCAP, from whom licenses can be obtained for music and both composition and any lyrics. But if you're altering the music in such a way that you're synchronizing it to the images, then that implicates another right. And that is different from probably the permissions you're getting, unless you specifically address it in your license. So who owns the rights in music? So you have multiple layers of rights ownership with music. You have the composer and lyricist own rights in the original composition and any lyrics. But in addition, you have a recording copyright. So whoever records the music owns the rights in the recording. Typically that will be a label, a record label. And so if you're only licensing the lyrics and composition and not the recording, then you have to make your own recording of the music. But if you are licensing everything, if the license should say so. And then if you're synchronizing music, that's an additional license. And that is probably going to involve a new recording of the music. So in all likelihood, you're going to want to go to the composer and the lyricist for those rights. Okay, so clearance is an important way to avoid DMCA takedowns, but there are other third-party rights as well. In addition, there can be trademark issues or unfair false advertising issues, even outside of FTC issues. If a third party or competitor is shown in a negative light, you have to be very careful about how that wording or portrayal is done to avoid reputational injury to the competitor and in a way that complies with what we call trademark fair use. You have to have, if you're saying one product is better than another, you have to have data, you have to have evidence that it's better. You may remember those old ads with Coke tasting better than Pepsi or vice versa. They were based on consumer surveys, so they had some, backup for it. And in that case, they're allowed to use the competitor's name because they're making a comparison between products. But it's very, very tricky. It's not an area that you should enter into lightly, and you should make sure that if a brand is asking you to do this, that they bear the liability for the comparisons that you're making. And you should also protect yourself by having the content cleared. Okay, next slide. So we spoke briefly at the beginning of the presentation about merchandising. So what is merchandising? It's licensing your name, your brand, for producing goods or services with your name or brand associated with the goods or services. And these can include brand partnership deals where both the brand's name is used and your own name and your own brand. It can include curated collections of clothing or makeup as part of a brand partnership where you're authorizing the brand to use your name or your trademark on the merchandise and promoting sales of the merchandise. But these merchandise agreements have to be really well drafted to make sure that you get the most out of it in terms of a return on investment. Generally, you're going to want an advance and royalties on sales, but you're also going to want the brand to make a good faith effort to push the products that you're endorsing. So in situations where sales minimums aren't specified and a termination provision is there when those sales minimums aren't met, or where there's a limit on the brand's obligation to market in terms of geographic territory, you could end up with poor sales, and that is going to impact your bottom line. So a popular case where this happened with a celebrity influencer is Sean Combs, who partnered with Diego on his De Leon brand, and that ended very badly in a lawsuit because Diego was not, according to Combs, promoting his brand aggressively enough. The De Leon brand that wasn't being promoted geographically in enough places, according to Combs, and it just not, there weren't any sales minimums in the contract, so Combs is probably going to have a very hard time with this lawsuit because the contract did not specify the kinds of things I'm talking about. And in addition, you're going to want to have an attorney's fees provision if you're forced to collect on an advance or royalties. And generally speaking, these kinds of provisions are just a good idea to have if you're not paid. It's a good idea, for example, in talent management agreements, brand partnership agreements. I mentioned it was an important term. Okay, so we're on our last tip, which is FTC compliance. Critical to any influencer is being familiar with FTC's endorsement guides concerning disclosures of paid partnerships. Most recent guidance indicate that the Disclosure should be auditory, visual, or both, depending upon how you're endorsing the product. Most important, the disclosure should be clear and conspicuous, easily understandable, unless it's already clear that a promotion is taking place and you want to err on the side of caution and disclose. All kinds of content is covered: social media posts, videos, stories, reels, YouTube, podcasts, live streams, and the FTC has helpfully included at this link social media disclosures 101 for influencers. And material connections, it's important to know, don't only consist of a situation where you're paid for the endorsement, but also where you receive free products or there's some sort of business or family relationship between you and the owner of the brand. Next slide. I've included one bonus tip, which is to set up an LLC. That's really very helpful in a couple of key respects. First of all, it shelters the individual influencer or the manager from personal liability. So having that LLC means that nobody can reach your individual assets, your home, your car, or anything you own that's valuable cannot be touched as long as those are in your own name and not the LLC's. And it's also a really convenient way to sort of keep all your, what I call intangible property, which is intellectual property. Your merchandising rights, your publicity rights, your trademark rights, your copyrights. So your LLC can own your trademark registration, can own the copyright registration, can enter into brand endorsement agreements, can enter into merchandising agreements, and all of the revenue can be tracked that way, so that for the talent manager, this is, in addition to making it easier from an accounting standpoint and tax standpoint, for the content creator, for the talent manager, it may also help when they are exclusive with the influencer, because the revenue can be used as a basis for calculating the agency fee, the talent manager's fee. And that is all I have, and I actually managed to end on time, even though we've had a slow start. So I am going to take a look now at the chat to see if we have any questions. Okay, so I see we have a question here again about what merchandising entails and what kinds of rights are conveyed in the merchandise license. So I think that you have both copyright and trademark potentially implicated, because to the extent that you have copyright in a particular product design or other content is going to be licensed to the brand. Maybe you're creating bespoke content. That would be a copyright license, similar to when you are entering into an endorsement agreement, but also you may be licensing your name, your brand, and in that case, trademark rights are implicated, and as well, you have right of publicity rights implicated. So a merchandise licensing really is all of the rights that you're conveying in connection with the license. I don't see any other questions, but feel free to reach out to me here. You can also connect with me using these QR codes on LinkedIn. And you can also subscribe to our More Than Your Mark blog, which frequently covers topics of interest in the creative economy. Thank you so much for joining today. Bye-bye.